This program is brought to you by Emory University.
Well, welcome. I'm Robert Shapiro, Dean of Emory Law School, and it's my great pleasure to welcome you to the 4th Annual David J. Biederman Lecture. This distinguished lecture honors our dear departed colleague, David Biederman, the K.H. Geer Professor of Private International Law. I'd like to offer a special welcome to the family of David Biederman, to Lori and Annalise, and to David's parents, Jolene and Sanford. Special thanks are also due to Abdu Anaim, Judge Dorothy Beasley, Edie Bridges, and to the outstanding marketing and communications team of Emory Law School for all their help in coordinating and arranging today's lecture. And we are grateful as well to the Biederman Lecture Committee for identifying and inviting our distinguished speaker. At Emory Law, we seek to advance the rule of law and promote positive social transformation through the students we educate, the ideas we create, and the service we perform. A key aspect of the rule of law is a system of international law to govern the disputes of private individuals. Law, in this sense, is more than a means for a particular polity to resolve its own internal conflicts. Law is how a global society aims to find principles that apply when disputes implicate multiple legal systems. I'm reminded here of the work of our dear departed colleague Harold Berman, who was a mentor of David Biederman's. Hal always stressed the broadest significance and meaning of law as when he advanced his notion of world law. Hal wanted to emphasize that law was not simply a system operating within a given state or governing the relations between different states, but actually established fundamental principles to guide the relationship of individuals whose personal and professional endeavors cross state boundaries. This kind of private international law is a critical feature of the rule of law. David Biederman was a great scholar and practitioner of private international law, and today's speaker, Symeonides, has been described as the world's leading expert in private international law. So first, a word about the man in whose honor this lecture was established. David served on the faculty of Emory Law School for 20 years. His range of expertise was broad and deep. It included, of course, international law, but also admiralty and legal history, constitutional law, and federal jurisdiction. He was the author of 125 articles and 12 books, and presented more than 80 public lectures at distinguished universities and learned societies around the world. Equally at home in a library, classroom, boardroom, or courtroom, David was a skilled advocate. He served as counsel of record in 52 cases in the United States Court of Appeals, and he argued 4 cases before the United States Supreme Court. His clients ranged from the Ministry of Defense of the Islamic Republic of Iran to the salvors of the Titanic, and he won both of those cases. Always looking to share his intellectual opportunities with his students, he was the founder of the Emory Law School Supreme Court Advocacy Project. David was an outstanding scholar, teacher, colleague, lawyer, and friend. And all of this he accomplished before his death in 2011 at the age of 50. Today's Biederman lecture embodies David's vision of seeking to realize the ideals embodied in a system of international law. A native of Cyprus, Professor Symeonides holds 2 LLB degrees, one in private law and one in public law, from the Aristotle University of Thessaloniki, Greece. He also holds an LLM and an SJD from Harvard and 2 honorary doctorates. Professor Symeonides is an extraordinarily prolific and influential scholar. He has published 25 books and more than 100 articles in 7 languages, focusing on conflict of laws and comparative private international law, including the widely read surveys of American choice of law cases for the last 28 years. His work has been cited by the Supreme Courts of the United States and the United Kingdom, and he's been honored with numerous scholarly prizes, including one for lifetime achievement from the American Society for Comparative Law. Professor Symeonides is also president of the International Association of Legal Science and former president of the American Society of Comparative Law. Professor Symeonides has delivered distinguished lectures around the globe, including at the Hague Academy of International Law. I'd like to mention that's an institution of special significance to the Biederman legacy. It is, of course, where David and Lori met, and where Emory law students will now be attending classes each summer thanks to the Biederman Fellowship established in David's honor. Now, on a personal note, I'd also have to say I find it particularly noteworthy, and I must say thoroughly humbling, that Professor Symeonides ascended these Olympian heights of scholarship while also serving as dean at the Willamette University School of Law from 1999 to 2011. Don't know how he did it. Professor Symeonides now holds the Alex L. Parks Distinguished Chair in Law and is Dean Emeritus at Willamette. We are honored to have Professor Symeonides deliver the 2015 David J. Biederman Lecture on the topic of codifying choice of law around the world, the last 50 years. Please join me in welcoming Professor Symeonides.
Thank you very much, Dean Shapiro, for this very generous, unduly generous introduction. Good afternoon, ladies and gentlemen. Thank you for choosing to be here today. It's my pleasure and my honor to be here. And I want to express first my appreciation for the flattering invitation to deliver this prestigious lecture. First, I want to thank Professor Al-Naim for nominating me, then the Biederman Lecture Committee for selecting me, and then to Dean Shapiro for extending the invitation to me. This is the fourth David J. Biederman Lecture, and the third one to be delivered by a speaker with a foreign accent. It must be the nature of the subject matter. It is really a high honor for me to have my name associated with David J. Biederman, an intellectual giant, a scholar seen only in a generation, once in a generation, a man of enormous erudition, boundless intellect, but also a man of compassion, imagination, rigor, humor, and the wisdom of the ages. You may have recognized these phrases, and that's because they are not mine. They are from people who have known David, including his beloved wife, Lori. As Dean Shapiro wrote at the time of David's passing, David's record of scholarly achievement was impressive to the point of being improbable. Improbable and yet true. That was David J. Biederman, and I'm truly humbled to be here today attempting to talk about topics that David, as a professor of private international law, knew inside and out. I'll do my best not to disappoint you. My topic is codifying choice of law around the world, the last 50 years. It is based on a book I published recently, which covers 2 substantive areas and 4 general themes, and I will talk about some of them, the ones that are underlined. This last 50-year period, at least 50 years from when I was finishing the book, that is 1962 to 2012, has been a very productive period in terms of codifications of private international law. And by codification here, I mean systematic statutes that deal exclusively with this subject. We have had 94 national or subnational, sometimes, codifications, 15 EU regulations in the European Union. Regulation in that lexicon is a comprehensive federal law that preempts national laws. 29 conventions on private international law adopted under the auspices of the Hague Conference of Private International Law, and 26 inter-American conventions, altogether 164 documents. Chronologically, by decade, you see how they stack up. And if you include in this count some model laws and other protocols by UNCITRAL and Mercosur, Mercosur in Latin America, UNCITRAL internationally, you have a total of 196 documents. And that's why this is the most productive period, 50-year period since 1313, which is the year of the birth of Bartolus of Sassoferrando, who is considered the intellectual father of modern, or at least post-classic private international law. Geographically, you see the codifications are mostly in Europe, but not only. You have a lot of them in Asia and even in Africa and Latin America. This is the most productive period, as I said, and you may wonder why so many codifications during this period. Well, part of the reason, of course, is the decolonization of Africa and parts of Asia, but also later on the collapse of communism in Europe. But there must be other reasons too, including the tremendous upsurge of cross-border activity even before the phenomenon that we now call globalization. So whatever the reasons, that activity answers the question of whether private international law is susceptible to codification, because believe it or not, until the 1950s, that was the prevailing view, that it was not susceptible to codification because it's such a fluid matter and so on, with so many imponderables. Well, we have 32 codifications in Europe, and that is during this period. This is why, for example, France or Greece are not highlighted in yellow. They have had their codifications, but did so before the 50-year period that is the object of this book. 21 of these codifications come from from countries of the former Soviet sphere, a region that before this period only had 7 codifications. And here you see them. You see how many of these countries belong to the European Union. And within the two groups, you have in pink the countries of the former Soviet sphere. Altogether, 32 codifications in continental Europe. We have had 19 codifications in Asia. Again, in red, I mark the countries of the former Soviet republics. In Africa, we had a few right after the 1960s. The African codifications tend to be shorter. In red, I mark the countries that used to be Portuguese colonies, which have adopted the Portuguese codification of '66, which was pretty good, but reenacted it after independence. In the Americas, you don't have as many codifications, and that is because all of Latin America, South America had adopted codifications in the 1930s following the Bustamante Code, so-called. So since then, a few have recodified, have revised their codifications, and you will notice that in the United States, there are only 2 small places. One of them is Louisiana, and the other is Oregon, and you may wonder what is the connection there. The old codifications of private international law used to be part of a civil code, usually in the preliminary title. That tradition is preserved, but also is changing at the same time. You have a lot of freestanding codifications, 36 of them. The others are part of a civil code, and the last few are part of another code, like the Code of Persons. Some of them are very long, like the Swiss codification consists of 200 articles. Some of them, especially the African ones, are very short. The ones that are long and freestanding statutes usually deal not only with choice of law, but also with jurisdiction and recognition of judgments. Now, a few things about the law governing torts. You may remember what is the traditional rule for tort conflicts. That is, what law governs torts? Well, it's the lex loci delicti, meaning that we apply the law of the place of the tort. Well, what is the status of that rule after these codifications? Well, a lot of them have adopted that rule, have readopted it, but they subject it to exceptions. Only very few of them do not have exceptions to the lex loci rule, and only one country, Yemen, says we don't apply the law of the place of the tort, we always apply the law of the forum. So the lex loci delicti rule survives, but it is a different one now because it is subject to so many exceptions. So we carved out all of these exceptions, the most common of which is that when the parties, the tortfeasor and the victim, have a closer connection with a state or country other than the place of the tort, then we apply that law, or especially when they are domiciled in the same state or country, or they are parties to a pre-existing relationship like an employment relationship. So a lot of exceptions now, and I will not bore you with the details. I'll take one of the exceptions, the common domicile rule or exception. It appears in the different verbal formulations, parties being domiciled in the same state or residing in the same state or having the same nationality, with various variations. In some countries, this rule appears in bilateral form, that is, applies whether the parties are domiciliaries of the forum state or a foreign state. In some other countries, it appears only in unilateral form. It applies only when the tortfeasor and the victim are domiciliaries of the forum state, but not the other way around, and that is a little protectionist, and we'll say more about that. Okay. Now, if you look at all the codifications of this period, you see that 47 of them have adopted the common domicile rule. It's interesting to compare that with the American experience during the same period, that is from the 1960s to today, where we have had the so-called choice of law revolution, where we abandoned the old system and adopted a lot of flexible approaches and so on. What are the results of that revolution on this specific issue? Well, very similar. That is, 42 out of 52 American jurisdictions have adopted judicially, and in 2 cases legislatively, the common domicile rule. So parallel or similar results, though through different avenues. Here is another exception to the lex loci delicti rule that is also protectionist. That is, it's the double actionability rule. That is, in order for the plaintiff to recover, the conduct that occurred outside the forum state must have been actionable both under the lex loci and the law of the forum. If you don't meet the second requirement, you don't recover, which is a rule, if you think of it, that protects defendants and usually forum defendants. Just keep that thought in mind. And other exceptions to the lex loci, we are willing to apply foreign law if the tort occurred abroad, but when it comes to the amount of damages, we are not going to give you more than our law allows, says Switzerland or Germany or Japan or whatever. So another protectionist rule. Again, keep that thought in mind. What about cross-border torts? That is, situations where the conduct occurs in one country and the injury in another. Think of product liability, defamation, anything that can be committed across national boundaries. Well, surprisingly, 29 codifications apply whichever of these 2 rules favors the plaintiff, provides recovery. Compare that, the old system in the United States provided for the application of the law of the place of injury, for better or worse. This country says, why not apply either one, whichever favors the plaintiff? And 29 codifications do that for all types of torts, and 23 codifications have this rule for certain type of torts, like, for example, the Rome II regulation, which applies throughout the EU, has this rule only for environmental torts. So whichever favors the plaintiff. It sounds a bit unfair to defendants, does it not? They have no qualms about that. In fact, they call this the favor-lazy rule because it favors the injured. Well, how about, these are the results in these codifications. What about the same issue in the United States? I have studied the cases of the last 50 years, and that's how they stack up. 86% of the cases apply whichever of the two laws favors the plaintiff. They don't say that's the reason we do it. They base their decision on state interests and this and that and expectations, but in the end, these are the results. So same results, except that we reinvent the wheel in every case. Now, here in these cases, I don't include product liability cases, which I studied in another study, and it happens that in product liability cases, most of which are cross-border, the results are more pro-defendant, or they are actually evenly split. But if you mix the two together, and why are they different in product liability? It's only because the period of study is more recent. I only have the last 25 years, and for some reason, the decisions in American courts have become more conservative. It has to do perhaps with more Reagan appointees to the federal bench and all of that. So if you mix the two categories of cases together, this is what you get. So it's more similar to what is happening internationally. There should be some caveats in the comparison. In some respects, it's apples and oranges and so on. So I'm not making a big claim of statistical identity here, but it's just interesting how different systems through different avenues reach more or less parallel results. Speaking of product liability, these are examples of some statutory choice of law rules in various countries. They give the plaintiff a choice between the laws of various places: the victim's domicile, the place of injury, the place where the victim acquired the product, and the defendant's principal place of business. So the plaintiff gets to choose, and only in some codifications they provide the defendant with a defense that of lack of foreseeability. So it is a very pro-plaintiff rule that they have in many of these countries. You'll notice that very few of these are export countries. Most of them are import countries, and that has something to do with exceptions. I'll talk about Quebec later on, which has a pro-plaintiff rule here, but not when it comes to certain products that Quebec exports, like asbestos or other raw materials. Okay. Now, traditionally, we are trying to explain or understand how laws operate in space, and we think in terms of two grand principles. Historically, the first principle was the principle of personality. If you go back to the times of the Roman Empire, the laws followed the person. Roman law governed Romans wherever they were. You might say, well, they were an empire, they could do whatever they wanted, but they had the converse too, in that Greeks in Rome were governed by Greek law, and Egyptians were governed by Egyptian law. So the law followed the person. That was the governing principle then. And then, of course, the 16th century on, you have the principle of territoriality, the emergence of modern nation states and all of that. That became the modern principle. And when you come to the 19th century, it displaces completely the principle of personality. So at least in the area of torts, that is the governing principle, and that's why you have the lex loci delicti rule. So in the beginning of this period, both our system in the US and internationally, private international law, subjected everything to to the principle of territoriality, but as a result of this revolution in this country and the 50-year codification effort elsewhere, we have moved in the US towards the principle of personality, if you think, for example, of the common domicile exception or rule. But so have these other countries. So then what do we learn from this development? It's not an either or. It doesn't have to be either or. Some laws operate territorially, like those that regulate conduct per se, and some laws may follow the person, like the laws that determine immunities, charitable immunities, family immunities, or even the amount of damages and so on. Okay. A couple of things about party autonomy in contracts. The idea that parties should have the freedom to select the law that will govern their future contractual dispute. A lot of countries, in fact, virtually all the codifications of this period have endorsed the principle of party autonomy. It's like applehood, like apple pie and motherhood. And you might say, well, what is remarkable about that? Well, precisely because before this period, very few countries had accepted this principle that today we take for granted. And incidentally, that goes for the American system as well. The first restatement did not recognize this principle because ostensibly it gave parties the power to legislate. So you have this principle of party autonomy now being a universal principle of private international law. But of course, the various countries differ on what is included in the scope of party autonomy. Some accept certain contracts or certain issues like capacity or form, or they don't allow party autonomy for non-contractual issues. Some of them do, and so on. So there are differences. And of course, there are differences in the threshold that they apply for policing party autonomy. I will not bore you with the details, but there is much more in the book if you are interested in reading it. Here I attempt a comparison between the American system as represented in the Restatement Second, which is followed in the majority of states, other traditional systems elsewhere, and Rome I, which is the EU rule. And what I can tell you briefly from this is that the Restatement Second has one rule for all contracts, but has a low threshold for party autonomy, whereas, for example, the Rome I regulation has a high threshold for some contracts and a protective rule for other contracts. The bottom line being that for consumer contracts and employment contracts, they have a very protective system that protects consumers and employees. And for the rest of the contracts, they have a very liberal system where anything goes. So it's interesting to compare the two philosophies. They have bright rules to protect some people. Politically, it's easy for them to draw these bright lines. In this country, politically, you cannot do that. So they have bright rules protecting employees and consumers, and then a very liberal regime for everything else. There are drawbacks to that system because there are some weak parties that don't qualify as consumers or employees, like franchisees, and then they are left out in the cold. Our system does not protect anybody a priori, legislatively, but thank God we have courts that watch over our shoulders and they step in to protect the weak parties on a case-by-case basis. So each system plays to its own strengths. Another theme now, flexibility in codifications. It's almost an oxymoron. Can codifications be flexible? Of course, this tension between legal certainty and flexibility is as old as law itself. Aristotle identified 23 centuries ago when he spoke of the role of equity as a corrective of the positive law. This tension is particularly present in private international law. As Voltaire said once, uncertainty is an uncomfortable position, but certainty is an absurd one. I call this the mother of all conflicts. Speaking of conflict of laws, law must be certain and predictable on the one hand. It must be flexible and adaptable to individual cases and changing conditions. So what is the proper equilibrium? It's very relevant to the issue of codification because the standard arguments against codification is that codification is inherent, or legislation for that matter, is inherently incapable of capturing the nuance and sophistication necessary for just and satisfactory choice of law solutions. This is a quote from one of my mentors, Professor Trautmann. That codification petrifies the law, it impedes its smooth development and adaptation to changing conditions. It impedes the individualized handling of unanticipated and exceptional cases. Well, is that true? Maybe it was true about the old codifications, but is it true of the new codifications? If you look at them carefully, you realize that it doesn't have to be. The modern codifications have developed a lot of techniques that inject flexibility, like rules with soft or flexible connecting factors. I'll give you a couple of examples later. Or alternative connecting factors. You apply either this law or that law or that law, whichever accomplishes a certain result. They have escape clauses, and some of them combine rules with approaches, which is a peculiarly American idea. So if you think of the whole spectrum of choices, you have traditional fixed rules on the one hand, and ad hoc approaches, of American-style approaches, namely a list of factors that the court should consider to arrive at a decision. And in between, you have several combinations, rules with alternative connecting factors or soft connecting factors, or a combination of rules and escapes approaches and so on. I'll give you a couple of examples, beginning with the most ubiquitous of these soft connecting factors, the concept of the closer connection, which functions either as a connecting factor pointing to the state of the applicable law or as an escape from the established rules, and for all of the rules of the codification or some of these rules. So the Austrian codification, for example, provides that multi-state cases shall be judged according to the law with which the strongest connection exists, and the choice of law rules of this codification shall be considered an example of that principle. So all of the rules of the codification are supposed to be based on this idea that you are trying to find the state that has the closest connection. And you see that same idea in several codifications in different parts for different areas and so on. This concept performs a lot of different functions. For example, take the last example there. For all the unprovided for cases, we give you a number of rules. We don't provide for all possibilities, but we have this last rule. For all the cases we don't provide here, apply the law of the state that has the closest connection. So, of course, that gives judges a lot of flexibility. There are other soft connecting factors. In Louisiana, we use the term, you apply the law of the state whose policies would be most seriously impaired if you wouldn't apply its law. In Oregon, we have a similar soft connecting factor and so on. And you can find similar soft connecting factors in other codifications. Escape clauses. Again, based on the closer connection, here is the general escape. The law of the state designated as applicable in the choice of law rule should not apply if that state has a very slight connection and another state has a much closer connection. That is a standard formulation you find in these codifications. So it's an escape or an exception from all the rules of the codification. It requires a judge to compare the connections of the two states. This escape, when applicable, displaces not only foreign law but also forum law. The threshold for employing them is usually high. They operate in a geographical rather than qualitative way. and so on. So they are not too flexible to satisfy the American standards, but they are still flexible enough for their standards. And looking at the goal, I will move more quickly. Notice that they have these escapes even in areas like property, where certainty is supposed to be the supreme value. You expect to see them in torts and contracts, but also you find them in other areas. Here is an example of an escape that is not based on the principle of the closest connection, but a similarly soft and vague idea. The rule says in the Russian codification, for example, that state X is the state that has a closer connection a priori, but if it otherwise follows from the totality of the circumstances or the peculiarities of the case, the court can apply the law of another state. So similar, you have a lot of other similarly phrased vague exceptions. And finally, you have the idea of an approach which was considered a very American idea, because you only give the court a list of factors which do not determine the result in advance. They are considered incompatible with the very notion of codification, but in Louisiana and Oregon, we concluded that they are very compatible. So the codifications of the two states, as well as the Puerto Rico draft, are based on the idea that you can have a general approach, then specific rules extracted from that general approach. The rules cover many of the cases where you can feel comfortable enough to produce an uncontroversial result, and then you leave the rest to the general approach. It's a very interesting relation, dialectical relation between the general approach and the specific rules, and you have escape clauses. So it is possible to have a combination of rules and approaches. In any event, let's now look again, compare developments on this issue, the tension between certainty and flexibility in these codifications, and what was happening at the same time in the US. In the US, we had the traditional system of the first restatement, where legal certainty and uniformity were the supreme values. The drafter of those rules was Joseph Bill, whose rules turned out to be quite bad. And because these rules were bad, and because judges have a better common sense, they began deviating from them gradually, and in the end, massively, and that's why we had what we call the American choice of law revolution that began in the 1960s. The revolution now led to the abandonment of all rules, not just the bad rules of Joseph Bill, because Brainerd Carey, the leader of the revolution, said that it's not just that these rules are bad, it's all rules that are bad. A typical, he was a legal realist, so you understand, they were a little extreme, or exaggerating, or provocative. So the revolution did not produce a new system. In fact, it didn't aspire to produce one, but produced instead several malleable approaches, where each case is decided ad hoc. We have too much flexibility and unpredictability. American conflicts law is now a story of 1,001 cases, said a friend of mine, and I should know because I read them all. So what about the rest of the world in the same period? We have had a quiet evolution toward flexibility. Most choice of law rules were statutory, and almost none of them were as bad as the American rules, but even the bad rules were gradually repaired rather than demolished. And the new rules, as we have seen, provide small dosages of flexibility through these various devices and escape clauses. So from Portalis, who is the drafter of the French Civil Code and knew something about flexibility, I don't put here Bismarck, the German code, but I put Portalis. We have had now some new examples of how flexibility can be combined with certainty. So going back to Voltaire, again, it doesn't have to be an either or. You can combine the two, as we have seen, and produce a proper equilibrium between these two perpetually competing values. And that's an apt lesson for us in the United States, because we went a bit too far to the other extreme of flexibility. You know, they haven't got it perfectly in the rest of the world. They still, their escapes are not drafted in terms of issues and so on, but still it's a sign of progress, I think. So where is the pendulum now in the two issues, in the two values? In the US, we went from the one extreme to the other. Hopefully we'll come back towards the middle now that we have decided to begin drafting the third conflict statement, which I have been preaching for the last 20 years. In the rest of the world, they moved towards flexibility, but not as far as we went. But they have their own dangers now, because within the EU, and that could be the topic of another lecture, because I spent 6 months in Europe working in the belly of the beast, they are turning the clock back because it's a multi-ethnic union. They have to, you know, and so on. They are, but that's their problem. So another topic, I think I can do this. Here, well, let's go. Yeah. Here is the big dilemma. Again, the old, the prevailing view took this position that the choice of law process should aim to find the law of the proper state, that is, the state that had the proper geographical connections with the case, regardless of the quality of the results that the application of that law would produce. So you can call this spatial justice or geographical justice, or the prevailing term is conflicts justice. And here are the classical people's stories. Savigny subscribed to this idea, and the one that really articulated it in the 20th century is another German scholar, Kegel. Or is that the proper approach? Is that the proper objective? Or should the choice of law process aim directly for the proper result, that is, the result that produces the same quality of justice as the one to which we aspire in fully domestic cases? That is the objective of real or material or substantive justice, and the primary exponent of that view was an American, Robert Loeffler. But the same idea appears in the post-classical Roman period with Magister Aldrigus. So what should be our objective? The prevailing view is that it's only geographical justice. But if you look carefully at these codifications, you see that material justice has made a lot of inroads into this idea. And I will give you examples. Or take one example. What law governs the formal validity of testaments, wills and testaments? You have the Hague Convention that gives you all these choices. Apply whichever of these law favors the validity of the testament. We have similar rules in this country in the Uniform Model Probate Code, and 44 additional countries have this kind of rule, okay? What law governs the formal validity of a contract? Several codifications give choices. Apply whichever of these laws upholds the contract as to form. So the substantive result that is preferred is upholding it rather than not upholding it. We have rules that favor a certain status: legitimacy, filiation, acknowledgement, adoption, validity of the marriage, same-sex unions nowadays, or favoring divorce. We have rules we have seen earlier in cross-border torts, give the court or the victim the choice, applying whichever law favors the plaintiff. Products liability, we have seen those rules. You have similar rules for favoring the owner of stolen property, especially cultural property, or the unwed mother. Maintenance obligees, children and other weak parties. Protecting consumers and employees from the consequences of an adverse choice of law. Again, result-oriented rules. So then, It's not only in America that we have a better law approach proposed by Leffert, followed in 5 states, but also influencing other states. It also happens in the rest of the world, where virtually all codifications have introduced result-selective choice of law rules. Of course, there's a big difference between the two in that under the American version of this idea, the choice is made a posteriori by a court, by a judge, whereas in these codifications, it is made a priori by the legislature through the collective consensus producing mechanism of the democratic process. Final theme, well, no, we're still conclusions from the previous theme. So you see how we have moved towards the idea of material justice in this country, but the rest of the world has followed a little bit too. So it's, again, not an either or. Private international law is not indifferent or should not be indifferent to material justice. My final theme is the politicization of private international law. Again, we take the classical view represented by Savigny and Story that looks at private international law as private law, that is one that implicates only the interest of litigants and not their respective states. Looks at it as international law, not in the sense of its sources, but in terms of its aspirations. It is, of course, formulated by national lawmakers, but they should be acting as noble surrogates of an international lawmaker. They should aspire for national uniformity, international uniformity, and they can achieve that if they treat foreign and foreign law equally. They don't give preference to their own law, their own people, and if all countries adopt the same choice of law rules and apply them the same way, which is a big if. And then here comes a new perspective, a heretical view espoused first by Brainerd Carey in the US, that looks at private international law as the law of conflict of laws, conflicts. And conflicts exist because the involved countries have different laws reflecting different values, policies, and yes, interests. So states do have an interest in the outcome of private international law disputes. And this private-public division, which was never accepted in the common law world, is not accepted here either. Legal rules always embody public interest, even when they appear to protect only private persons. And in each conflict, each state wants to see its interests vindicated or at least not sacrificed. So these interests must be taken into account in properly resolving private international law disputes. So conflict law is very much national law. International uniformity is illusory. We should aim at intrastate uniformity rather than international uniformity. So that was Brainerd Carey's approach. American courts have not fully accepted it, but in many respects, it reflected their views anyway, in some respects. In the rest of the world, these views are considered too American, too heretical, until you look at the specifics, especially under the surface. So they have plenty of statutes in these countries that say that, German law applies to these cases no matter what we provide in the private international law code. That's an example, okay? They have, these codifications give priority to this, what they call mandatory rules of the forum state, namely rules that apply regardless of anything else in the code. So there are some differences between the two. I will not bore you. They have unilateral choice of law rules that tell you when German law applies, but they don't tell you what happens in the converse situation, whether you will apply American law. And they have multilateral, facially neutral, but not so neutral rules, like you take the product liability rules. In import countries, take Tunisia, their choice of law rule is very pro-consumer. In Japan, if you look at their rules, they are very pro-manufacturer. And in Quebec, as I told you earlier, they are pro-consumer for most products, but when it comes to raw materials produced in Quebec, they apply Quebec law no matter what, and they claim exclusive jurisdiction. So you see, protectionism can appear in various forms, and it is usually disguised. The same is true of the product liability rule of Rome II, which you have to read 5 times to understand how cagey it is and how it protects German consumers and at the same, EU consumers, and at the same time EU manufacturers. And you wonder, how could that be possible? And it is. So, I gave you earlier the double actionability rule as an example of protectionism and the lex for eliminations on damages. So then there are various ways of protecting the forum's interests through these localized rules, through mandatory rules, through unilateral rules, and through bilateral but partial rules. So altogether they form a buffer protecting the forum's interests. So they exist in every country. They may be methodologically exceptional, but they are too numerous to be dismissed. They are employed in all fields of law, not just public law, so-called, but also like antitrust, but also in contracts, property, succession, marriage, divorce, maintenance, and so on. They protect not only economic interests of the enacting state, but also certain strongly held societal values and beliefs. And so that is why, so there is protectionism everywhere, not just in the United States. And that's why private international law, they say, has lost its innocence, if it ever had it. So, yes, we move towards anthrocentricism in the US, but so has the rest of the world. Okay, I'm done. Almost. So looking back at all of these codifications, all I can say is not your grandfather's codification. They are much different than those of the previous generation. They are more comprehensive, complex, flexible, pragmatic, clever, pluralistic, and eclectic, and less idealistic, pure, and innocent. And if I can take a little bit the eclecticism theme, eclecticism being the opposite of purism. What is purism? Whether in grammar or in vocabulary or in law, it always means ignorance, said someone. So in the last 700 years, since the birth of Bartolus, private international law has tried purism and found it wanting. And so it moved to a pluralist methods, as Badifol said. When pluralism is voluntary rather than forced or accidental, it is called eclecticism. And it is bad when it is subservient imitation or it is the result of intellectual laziness. But if it's studied and adapted and thoughtful, eclecticism can combine the best of both worlds, and it can live up to the true meaning of this Greek word that literally means choosing well, not just choosing well. So for better or worse, contemporary private international law refuses to take the purist route that many academics passionately advocate. It has no qualms about combining ideas that their proponents have posited as polar opposites. Contemporary private international law is pragmatically eclectic and in that sense pluralistic. Perhaps the modern legal mind has come to realize that the complexity of contemporary private international law problems requires a toolbox approach. The more tools, the better, rather than a single tool or method. No single theory or school of thought has all the right solutions to all private international problems, but each school has something valuable to contribute. And rather than choosing a single school or method wholesale, it is better to draw the best ideas from each and properly combine them into a workable system. So in the last 50 years, most private international law codifications engage in such an eclecticism, and I think they have chosen well. So modern codifications provide certainty through black letter rules, but they also provide flexibility through several techniques. They aim for conflicts justice, geographical justice, but they also make targeted concessions to the desideratum of material justice. They consist primarily of bilateral rules, but they selectively employ unilateral rules whenever the important forum interests are at stake. They continue to view private international law as primarily private law, but they also concede that a private international law often implicates important public interests which must take precedence over other values. They continue to subscribe to the principle of equality of forum and foreign law, but they also selectively protect the interests of the forum state. There is a great degree of emulation, borrowing, and transplantation, especially from the sophisticated Western European codifications to Eastern European and Asian codifications. For example, the influence of the Rome Convention is pervasive. However, more often than not, the borrowing is not mechanical or subservient. It is usually accompanied by shrewd adjustments, carefully crafted to accommodate the national needs, interests, and values of the borrowing country. So this has been a very productive period, the most productive ever, and it confirms that 702 years after the birth of Bartolus, private international law is not only alive and well, but also more vibrant, sophisticated, flexible, pragmatic, and richer than ever before. Thank you for listening. Is it tradition to ask questions? Or?
Yes, yes.
First, let me apologize for trying to cover too much and stepping over my words, and with the bad accent, that's a bad combination. I hope you got some of it. But I will try to answer any question we have. Yes, ma'am. Judge.
Thank you. Well, that was quite something. Now, we all have to buy and read the book. What place does now, in so many business contracts, have arbitration clauses, right? Choosing the form. And the difference that it might make with the application of what you said on whether the two parties are in different places, where the contract is made in one place, performed in another place, or they don't know where it's going to be performed. Let's say what's the American Express card, something like that, or construction contracts and things like that. That all plays into this, and I just wanted to know, particularly since now we're trying to get more international commercial arbitration to Atlanta. Mm-hmm. There's a whole center now for that.
Yeah.
So I'm thinking in those terms, but can you tell us how that fits in?
Yeah. Well, I'll begin by saying that arbitration is really another universe. I mean, it's almost an autonomous universe in this sense that arbitrators usually don't have to follow choice of law rules. It depends what the parties provided. The parties can tell arbitrators which law to apply. That's a choice of law clause, party autonomy. And the arbitrators are bound to apply that law. So in a multi-state contract, they can say, we want you to apply New York law. By that, usually they mean New York substantive law.
That's what I mean too, is that might apply only to part of whatever problem comes down the pipe.
Right.
You know, whatever the wording they put in the clause might.
Right. And most of the contracts that contain an arbitration clause are likely to contain also a choice of law clause, which will tell arbitrators which law to apply, and the arbitrators should apply that law. And usually the choice of law clause is meant to refer to the substantive law of the chosen state, not to its whole law, which includes the choice of law rules. That is why in most arbitration cases, most of this is bypassed by a direct choice of law clause. Now, sometimes the contract does not contain a choice of law clause, and that raises the choice of law question. And how is that being answered? Under which state or country's standards is it answered? So there are several views on the matter, but the prevailing one is that the arbitrators will resolve the question of which state's law to apply under the choice of law rules of the state in which they sit. So if you bring the arbitration court in Atlanta, and you are dealing with a clause, with a contract that doesn't have this clause, the arbitrators should look at the Georgia state choice of law rules, which are somewhat traditional, if I remember, lex loci delicti and lex loci contractus, and so on, subject to some exceptions. So that's one possibility. But you know, in many contracts, the third possibility is that the parties may authorize the arbitrators to decide ex equo et bono, that is, under whatever law they consider appropriate, perhaps not even any particular law. That's the third possibility. Or, and more recently now, the parties will authorize or will require the arbitrators to apply even non-state norms, like the unilateral principles on contract and so on, or the credit card association rules in this country, which are drafted by the banks without any consumer input. In arbitration, parties are allowed to choose non-state law, and arbitrators apply these non-state norms. In litigation, we don't allow it yet. So if it comes before your court, a contract that has this clause authorizing you to apply the credit card association rules, you are allowed to say, we don't recognize these rules. But this is changing internationally. In fact, the Hague Choice of Law Principles for International Contracts, for the first time, allow or sanction the choice of non-state norms. Of course, they are not binding, they are soft law, but it's an example of how the landscape is changing. So, arbitration is another universe in many respects. In this country, we favor arbitration much more than other countries do. We allow it in consumer contracts, in employment contracts. We allow pre-dispute arbitration clauses for matters that involve personal injury and death. In other countries, that would be considered scandalous. So we have a very pro-business environment in this country, for better or worse. In other countries, they do things differently. Legislatively, it's almost impossible to have a change. You cannot touch the Federal Arbitration Act, for example. And thank God for judges who step in, at least in the egregious cases, to attempt to level the field. Okay.
Professor, nice to see you, because you know, I have read your article 10 years ago when I was a postgraduate. Because even those days, many of your articles have been translated into Chinese. But still, even in those days, I have a problem as to your article. And as the question remains until today, that is, I have two questions. Okay. As the two questions about your result selective approach, method or approach. I have the first question is that if you ask the judge to select results, that means it must prove the different countries' foreign law contents,
right,
and compare the different results and make a best choice in the concrete case. But do you think it's a great burden for the judge to prove the different foreign law? This is my first question. And the second question is that if the judge wants to make a choice, he must have standard.
Right.
For instance, in the case, in the custody case, the standard usually is the best interest of a child. But even in the domestic case, it's very hard for the judge to make a good choice, really good choice, to decide what is the best interest of the child. Do you think in the international case, do you think American judge can really find the best interest for a child with different cultural background? So do you think it's, of course it sounds great, but do you think it's an impossible mission for the judge? Thank you for your
No, very, very good points. So it's about result selectivity. The better law approach in this country is, of course, one example. And you're right there, you know, who chooses and what are the dangers? It's the judge who chooses the better law, and it's more likely to choose her own law is better. We've seen that in Minnesota and Wisconsin and all of that. So there is a danger of subjective outcomes in the better law approach as applied in this country. Now, in the rest of the world, you have two types of result-selective rules. One, it authorizes the court to choose a certain law, the law that favors the plaintiff, for example, in torts. And the other rules, the second model is the rules that give the choice to the plaintiff. Okay. So you ask, in the first case, how does the court choose which law favors the plaintiff? You have to know the two laws. And so you have to know the content of foreign law. And I know that many countries have a difficulty with that issue. In this country, we have the adversarial approach where it's the burden of the parties to prove the content of foreign law to the court. So in countries like China and Europe where the burden is on the court, you're right, there is a problem there. You put too much on the court's shoulders. Now, that is why the second model of rule says, let's give the choice to the plaintiff. She knows best, you know. And in drafting the last codification in Oregon, I adopted that rule. Because if you tell the court to apply the law that favors that accomplishes a certain result, you know, the court has to do its homework, and not only that, if you make a mistake, it's appealable. Whereas if you give the choice to the plaintiff, they should do their homework, and if they chose the wrong law, because you choose one law for all issues, and it may be favorable for some issues, but not for others. But you make the choice, it's not appealable, and it's efficient, and so on. So now, in all of these areas, you know, your example, by the way, the best interest of the child, it's a problem that you have even if the choice of law rule is not result selective. That is, because it may be that, you know, even in domestic cases, you have the best interest of the child as a standard for child custody. Sometimes it's very debatable what is the best interest of the child. We have developed standards domestically. You are right, if you have a foreign country, even if they have the same standard, best interest of the child, they may define it differently. But you have that problem even if your choice of law rule doesn't tell you to apply the better law. That is, you still have to make a choice between the two laws, and you'll have that problem. Many of these rules operate without many of these problems. For example, you know, the rule about legitimacy. You know, there are codifications that give the court 5 choices. Apply whichever of these rules will find the child to be legitimate. You know, what are these rules? The law of the place where the child was born, where his parents were domiciled at the time, where he's domiciled now, or this or that or that, whichever favors legitimacy, because that was, you know, the social stigma of illegitimacy, lack of inheritance. These are still facts, you know, realities in other countries. So these rules are easy to apply. They are not as difficult as the example you gave, you know. So, but the problems of proving the content of foreign law and the burden, the logistical and problem that exists, is a common problem in private international litigation, even in cases that are not covered by these result-selective rules. Now, the result-selective rules have their own problems. The better law approach has its own problems in that it is hard to justify why you give to a court the choice of choosing the better law after the fact. You know, I think it's more defensible to have a result-oriented statutory choice of law rule that has been agreed upon democratically and so on. Yeah, so that's as much as I would say at this point. Okay.
Okay. Thank you very much.